Events happen that change our lives. Dealing with change is what we do. We discuss with industry professionals objective solutions to work through cherished items and family memories. When we go beyond the gavel, we provide tools and information to deal with these crisis times.
Hi there, I'm Shane Feely with Auction Solutions. Welcome to Beyond the Gavel. As we've mentioned before, many times we had things happen to our loved ones that are critical occurrences and change their lifestyles. Today we've invited Monte Schatz to come in and talk to us about trust accounts, and how to take care of your belongings and what your family has before something like that happens. So it's a total preparation.
Thanks a lot, Shane, and thanks for the opportunity to speak on this topic on this forum. I hope we can give your viewers some good information to take away from this program.
Well, that'd be great. So let's just start at the beginning. What's a trust?
Okay, trust is really, it isn't as complex as it sounds or complicated. It can become complex, but at the basic level, a trust is an agreement, a written document that has three parties in it. A trustor or trust creator, the person who creates the trust for purposes that they specify in it. A trustee, the person or the institution that will handle the assets. And then a beneficiary, and that's basically who is the trust administered for. And all of those three parties can be the same person, and frequently are. But depending upon circumstances, they can be three different parties or two or three different parties. But anyway, those are your three critical parts. And the trust agreement is really the guiding document for all the parties of what can and can't be done with those assets that are held in a trust.
Okay, and why would I want a trust? Why would I be thinking about getting a trust?
Sure. There's been a lot of popular literature and media out there that, and there's people that promote these more as commodities than true estate planning vehicles. And what I mean by that is that some people want to just use it as a device to gather assets and to turn it into an investment tool and to gather assets for them. It's a popular marketing technique. Okay. But if you really cut to the core why you'd want to trust, one, I would say they're not for everybody, though I think it is, I think a majority of people would benefit from them. They are not tools exclusively for the super wealthy. They're more than for the top 1%. They can touch a lot of facets. But the main reason why you would want to have a trust, there are two or three reasons that you run into typically. One is for a dispositive tool at death. So you can set up the trust during life, and it tells the trustee what they can do with those assets and how they can manage and distribute those assets during the person's life, the beneficiary's life. But also in that trust agreement are provisions that say what happens should you become incapacitated, mentally or physically unable to handle Correct. It, or how to distribute those assets at death. Now, one of the popular messages you always hear is to avoid probate, and I think that has taken on kind of a negative connotation. Probate court isn't the inherent evil that some popular media and individuals like to promote. But as a will substitute, the trust does have benefits, and I think in many cases, if done correctly, can really expedite the distribution of assets from your estate. So that's the first one, dispositive tool at death. I think the one reason that doesn't get emphasized enough in discussions is a tool for incapacity planning, mental incapacity, which is a legal term, which in its broadest definition basically means no longer willing or able to manage your own assets for yourself. So, for example, if somebody has a trust set up and they were in a severe car accident and they were severely mentally damaged and their ability to make rational decisions is really limited, a new trustee can come in and take over that trust and continue managing the finances with that person virtually uninterrupted.
I see.
The second common area incapacity that we run into in incapacity is people that are elderly. We have an aging population. People are living longer. The reality is that a significant percentage of society will suffer dementia or Alzheimer's until we find cures for those diseases or are able to at least slow them. And so when a person gets to the point of where they can no longer make those decisions, they may be susceptible to what we call undue influence, basically doing things that they wouldn't ordinarily do and being influenced by another party. That trustee can come in at that point with the way it's outlined in the trust to take over as their trustee and protect them from unscrupulous vendors, relatives, unfortunately, sometimes, and other strangers that may come in. So that's another reason. And then the third reason that doesn't get talked about a lot, but is becoming more and more important, is for asset protection. So what we're talking about there basically is looking into the future. If the person that set up the trust has beneficiaries that might be spendthrifts, don't tend to manage their finances well, might have alcohol or drug problems, may have marital problems, may have an outstanding judgment against them. So let's say it's the person that created the trust's children, and one of them, it looks like they've had a history of an unstable marriage. Well, when the person that creates that trust passes away, that trust can become locked in and irrevocable. And then those assets that would have been available completely outright if they weren't held in trust to that son, and would have became part of the, or daughter, and may have become part of that son or daughter's divorce estate, now can be held in trust and protected and won't become a part of it. That's a classic example. So that's an important part. The fourth area is when we talk about tax planning. Trusts aren't the cure-all, be-all for tax purposes. Typically, there can be some tax planning that is done with them. When you get into the realm of federal estate taxes, which, as we all know, has increased significantly before an estate tax kicks in, there are ways that trust can be structured called A/B trust plans, whereby you can minimize federal estate taxes. But that's becoming less and less common because, you know, as of this year, an individual has an $11,400,000 exemption from estate tax. So a couple has almost $24 million that's exempt from federal estate taxes.
So when would you put a trust together to make it viable upon your having a catastrophic illness or something happen? Is it a 2-year, 5-year, 7-year, 1 year?
Sure. I think the best time to look at trust planning is the time frame called now.
Oh, okay. Nice.
Yeah. And the reason I say that is, you know, the best laid plans. Well, I don't need a trust now because I don't have that much wealth. Well, trusts aren't a function of how much wealth you have. It's a function of how do you want to plan for contingencies in the future for yourself and for whoever your ultimate heirs are, be they children, grandchildren, surviving spouse, you know, nephews, nieces, or charities, whatever the case may be. So you can address all those different kinds of beneficiaries. But the reason I say now is that you know, we have mortality. We don't know if, I think everybody, not everybody, but a lot of people, when they think about estate plans, they think about when I'm in the ripe old age and I'm retired and now's the time to set up my trust. Well, that's well and good, and that's a good time to do it if you haven't done it before, but I'd say it's equally as important, if not more so, when you are a young parent, because what happens, for example, if, you know, God forbid, you and your wife, you and your spouse are in a common disaster and both lives are taken, what's the tool that's put in place to take care of the children financially after your passing? Now, there are court procedures that you can do without a trust to do all that, but they're not as efficient. They are called conservatorships and guardianships, and conservatorships deal with the assets that a trust would typically take care of. And again, with the trust tool in place, if something catastrophic like that happened, then immediately upon the death of those parents, there would be this trust in place, a successor trustee that can come into place and preserve those assets for how they're outlined in the trust. And if there's still young children, it assures that you don't have to go through conservatorships because they're not of the age of either chronologically or emotionally to handle the assets. And you can specify the ages and for what purposes that trust money can be used for. And that's, not only thinking about the children, but whoever would be the guardian and assume responsibility of the care of those children.
Right.
It gives them a source of income, because if that surviving, say, brother or sister that takes over when the parents are gone, raising the children, that's going to be a financial burden on them, and having a trust in place can alleviate that because there's a source of funding to take care of all those needs that are required from additional children coming into a new household.
And it's actually laid out in a plan, so it's easier to follow, and really there's nothing to complain about by anybody who was not included in it if it's all laid out the way somebody wanted it. Right,
exactly. And the thing I'd like to emphasize about that is, I'm not saying that trust don't guarantee there's no controversy in families. People are people, okay? Sure. It'll happen in an estate. It can happen in a trust too. There might be some people that complain. But I think the critical piece is who are you going to have as your trustee? Make sure it's somebody that has financial acumen, that preferably, if they don't have a legal background themselves, obviously every trustee that is appointed is not going to be a lawyer, right? But at least that they have some financial sophistication and know the resources that are available should they run into issues about being the trustee.
What's the difference between revocable and irrevocable?
Yeah, it's on its face. I mean, those are the broadest ways to categorize trust. You hear all kinds of different terminologies for trust. You hear loving trust, living trust, testamentary trust. But at the base level, at its broadest level, where we start with is whether it's a revocable trust or an irrevocable trust. And a revocable trust, and of course there's different ways to say that too.
I'm sure.
Revocable, revocable, tomato, right? Okay, right. But no, getting to the serious point though, a revocable trust is just that. It's a trust that is set up during the trust creator's life. And at any point, that person that sets up the trust can put assets in and take them out as they wish. They can keep the instrument, the trust, in place for their whole life until their death or incapacity, which at that point it becomes irrevocable. But they're free to take assets in and out. There's no separate taxation of those types of trusts because it's what we call a flow-through type of concept. So it's a disregarded entity. So income taxes for that individual aren't affected. Everything flows through to their personal return anyway. But what that does is gives ultimate flexibility what to put in and not to. If they decide they don't like the trust, they can completely revoke it. And I've seen people do that for various reasons. Most people do not. Most people like the plan as it's put in place, but there is that option. An irrevocable trust is just as the name implies, it's the polar opposite of that. And that is that the trust cannot be revoked. And all trusts should be given considerable thought and consideration, but just by nature of the fact that it is irrevocable or irrevocable, just by nature of that fact, once you place those assets in there, they are in there and are made to stay there. Two primary reasons where those can become valuable tools. It might be the shifting of assets to pull it out of your estate so there's fewer taxable assets in your estate at death if properly structured.
I was going to ask you about that because I know that a lot of trusts don't hold real estate, or do they hold real estate? Because when I sell real estate, I get a book about this big, which is a copy of the trust to take the title company.
Right.
And it can be pretty extensive.
Yeah. So sometimes when you're talking about real estate, first of all, let's start with whether irrevocable or revocable. A trust can hold almost any type of asset, virtually. A lot of people think of them usually as tools to hold publicly traded stocks, bonds, certificates of deposit, and so forth. But the trust can virtually hold up to 100% of your assets, and to make it completely effective for purposes of not having to do a court probate and so forth, it really does need to have almost all the assets in there. There is a small estate procedure where you can have 50,000. That doesn't, if you have under 50,000, you don't have to go into probate. But if you have all of that in that trust, you have, because the trust agreement is only the step one. The thing that makes the trust effective, once the trust agreement is in place, that makes it more than a hollow shell, is transferring, entitling, funding the trust is what we call it. And that can include automobiles, real estate, any kind of personal property, stocks, bonds, virtually any type of asset. The thing that's critical important, though, to remember that a lot of people forget, and this is where trust can fail, is that once your attorney has drafted that trust agreement for you, like I said, that's less than half the battle in my mind. It's an important piece of it, but that's only half of it. Now you got to make sure it's funded. You got to execute all those agreements, bills of sale, assignment of interest, retitling of real estate, and filing deeds to make sure it's in the trust. That's what makes it effectively in the trust at that point in time. And the other piece that's important with that is that most people will have other types of assets that are not easily transferable into a trust because they have their own beneficiary designations, retirement accounts, individual retirement accounts, 401k plans, insurance, life insurance, those types of documents, payable on death accounts. And if you're not, for those types of assets that aren't easily transferable into a trust or have their own designated beneficiary, it's important to make sure that each of those respective instruments coordinate with each other, or you may end up with an unintended distribution scheme at your death.
Oh, I see.
Yeah.
So we talked about attorneys. So an attorney should be my trustee, or can I have an attorney draw it up and have a family member be my trustee?
Great question. And I think this is probably the most critical decision, and I think sometimes people might take that too lightly. Meaning that a good attorney should advise whoever you select as your trustee, and it can be an attorney, it can be an accountant, it can be a banking institution or an independent trust company where you want to have a professional trustee. You can do that as well too. It can be a friend, it can be whoever. But I go back to the premise of it should be somebody that has some degree of financial acumen and sophistication. That doesn't mean they have to be a legal giant in trust or understand every detail, but if they don't know the answers, they should at least know where to go to ask the questions, is how I put it. And they should coordinate with their lawyer in doing that, because how effective the trust is wholly really contingent upon how well that trustee administers it.
So one of my friends is managing a trust, which may have meant that whoever was supposed to do it may not be living anymore. She was appointed by the court, and it's taking a lot of her time, and she's very, very focused on that. Does that happen often, or?
It does, because I think sometimes that people, when they set up trusts, they think they default to their next of kin or somebody that's a good friend, and in some ways they might even think they're bestowing an honor on them. And to be trusted like that, granted, that is an honor, but what's more important, and you hit the nail on the head, is I talked about the degree of acumen and understanding of trust and your duties as a trustee,
Correct.
number one, and number two, the time that you have to dedicate to it. Because if you're going to do it right, and if you're not going to wholly rely on an attorney who may be billing out, hourly to administer every detail of it, you better be ready to dedicate some time to it, because you're responsible for managing all the assets. If a beneficiary comes to you and they're asking for a distribution, that's your call and decision to make. So you got to gather the information on that. You got to make sure all the tax returns are filed. An irrevocable trust, one that becomes irrevocable at death, has to file its own tax return. It's called a 1041 return.
Okay.
It's the trust equivalent of a 1040 tax return, if you will. So you got to make sure that that's all done. And then the income that's distributed out, you got to make sure that there's a form that reports the taxable income that goes out to the beneficiary. You got to make sure all those things happen, and not only the taking care of the beneficiaries, but making sure all the technical requirements that are required of a trust are followed and taken care of. And that does take a lot of time. And you got to do an accounting. I mean, you got to account for every transaction, what assets are held in it, where are the assets now compared to X number of months ago, a previous period, and how was the money distributed and what kind of money came in. It's almost like accounting for a little company, if you will.
Have you ever had any experience with them leaving it to their dog?
Yes, pet trusts are not that. In fact, I've seen it both in a, quote, regular non-pet trust, where they do set up within the trust agreement some type of a sub-trust where a certain amount of money is put in for the care and maintenance of the dog. And there are actually pet trusts. It's becoming a big area of law, and more people are treating their pets not a whole lot different than their human counterparts. And
like they like us more, they don't expect much.
Yeah, that's right. They're lower maintenance than most of their other beneficiaries, so why not, right? But no, people do think about leaving money for the care of the pet, and usually they designate in that instrument or make arrangements ahead of time who the caretaker is, and it may be the same person or it may not be the same person. I just got done drafting one trust for a family that they had a horse that was very near and dear to them, and there's a few humans that would be jealous of receiving that kind of money for their care and maintenance. But you start thinking about it, veterinary bills and hay and water and dog food or special nutrients. It can be an expensive adventure.
Yeah, well, horses. Well, just having a horse anyway is a little bit expensive, so
and the boarding,
that would make sense. I was going to ask you, does the trust always avoid taxes, or is that why some people do it as a tax shelter?
Some people do it as a tax shelter. That's typically in the context of the federal estate tax, which isn't, at the present time, isn't as critical because of the large exemption. Now, what a lot of people forget is that the federal estate tax, that high exemption level sunsets in 2026, meaning it goes away, and then, the gloves are off again in Congress as to where that's going to be. So people need to stay cognizant of it. There are some ways that you can set up trusts and so forth. For the mass of the population that isn't subject to federal estate tax, there is still income tax planning, meaning primarily income tax basis planning. Because when somebody dies, they get a stepped-up basis at death. That means their cost goes up, and then they can sell it with minimal to no capital gains and so forth. So there's some planning that can be done with trusts utilizing the trust as a technique.
What other documents, Monte, should I have besides the trust? We've talked about wills on our show, and we've talked about other things, but like due upon death. Talk just briefly about due upon death.
Okay, so here's payable on death can be a substitute for that. The only thing about payable on death that you need to be cognizant of is circumstances change, and if you've locked in a specific person that's payable on death and you had changed your mind, well, once you pass, that's locked in. Now you can change that during your life as well too, but what will happen is people will use a series, they'll have bank A, financial institution B, third place C, and they'll try to equalize payable on death, and sometimes that doesn't stay equalized. So that's not the best way to go, I think, for an estate plan. It'll work for some people. But the instruments you should have besides a trust, if you're going to have a trust-centered plan, is you still need to have a will, what we call a pour-over will. To the extent that the assets aren't funded in a trust, the will will pour over those assets that didn't get funded. You should still have a power of attorney, a financial power of attorney. And again, during life, should you become incapacitated, so there's a party that would be able to round up those assets that didn't get funded into the trust and be able to have the authority to transfer those into the trust. Then the other piece is a healthcare power of attorney, and some people would say a fourth would be a living will. A lot of the legal community is drafting the living will provisions in with the healthcare power of attorney. Healthcare power of attorney gives power to somebody to make decisions about your medical care should you not be able to make them yourself. The living will or end of life aspect of that is conveying what the wishes are of the person should they be in what we call a terminal condition or a persistent vegetative state. When, in layman's terms, under what circumstances do you want the plug pulled and no longer want to be sustained on artificial life-sustaining
Sort of
procedures?
like a DNR order.
Sort of like a DNR, exactly, yeah.
Well, Monte, I'm going to tell you, you are always have a lot of information to share. Monte Schatz, Vanden Eck Williams, we are so glad you came here today to spend your time with us beyond the gavel. Thank you so much.
My pleasure. Thank you, Shane.